Hey Sam.
Hey Marcella, how are you?
Great, thanks. How are you?
Good. Good to see you again.
Likewise.
Gotta figure out how to silence my phone. It's a new Android, so I'm not familiar with them. Hey Mike,
Hey Sam, how are you?
good?
Hey Marcella, how are you?
Hey there. Great. Thanks for having me.
Absolutely. Thanks for being with us. I was going to ask you real quick, Marcella. I was going to introduce you just as really, I think, what you're most known for, which is representing Ethan, Dr. Ethan. Is it Haim?
It's Haim, like time with an H.
Got it. And the gender affirming care issue over at the Texas Children's Hospital. I'm assuming is that still being litigated?
Yeah, we also represent Vanessa Sivage, who's a nurse whistleblower, and we represent Jamie Reed, who they'll have all heard of as well. She's with the Missouri Children's. And
Missouri.
we also represent the Vanderbilt whistleblower.
Oh wow. Okay.
I think that's all of them.
Yeah, that's a lot. You're quite busy. Um, okay, that's terrific. Um,
And we're going to talk about the transgender stuff, the conscience protections generally. And we're also going to talk about Title VII, which is discrimination and DEI, where the transgender stuff comes up.
yeah,
But so does reproductive stuff. Um, and just generally, I mean, yeah, high level discrimination.
yeah. Well, that sounds great. I have the list of questions here that you and Sam had gone over previously, so I think we'll pretty much keep to that. And then if you guys want to, speak beyond that, definitely do that. I think as we mentioned, a lot of the reason for tonight is to identify potential plaintiffs as well up here in New England. um, and have people up here, get to know the Burke Law Group. And I
And
invited,
Mike, by the way, I see that we have four people already joined, and I don't know if I don't know if people can hear us yet or not, but we might be live.
okay, yeah, let me see.
And how are we gonna do questions? Are we just gonna do those like we did last time through the chat?
Yeah, I'll take care of those. Yep.
Great.
Yeah, well, it's 7:59, so we can get started. We still have some people coming in, so maybe we'll hold off for about a minute or so. Let some more people kind of come in here. But welcome to those that have joined us on this webinar to help medical professionals understand their religious freedom, liberty, rights in the workplace. Um, I'm Mike King from Massachusetts Family Institute, and we have a few more people coming in here, so we're just gonna give it another minute until we officially get started. Um, so good to see more and more people coming in on this important issue of freedom in the workplace, especially in the medical workplace where um, there's a lot of discrimination going on, but thankfully there's a lot of whistleblowers. And we have one of the premier experts, attorney experts on this issue, representing many whistleblowers across the nation. So again, we're excited to have you joining us tonight. Give it just a little more time. We still have more people coming in. It's just 8 o'clock right now, so that's when we would expect people to be coming in. So again, we'll get started momentarily. All right. Well, as I mentioned, I am Michael King, president of Massachusetts Family Institute, one of the family policy councils of 40 family policy councils across the nation. I'm joined tonight by our general counsel, Sam Whiting, who many of you on this call I'm sure know, has been doing a lot of really great work to protect First Amendment rights here in the Commonwealth. And we are also joined by attorney Marcella Burke from the Burke Law Group, who has been representing many whistleblowers in the medical industry, especially when it comes to the gender affirming care issue in many of our hospitals, and perhaps most well known as they represent Dr. Eithan Haim down there from the Texas Children's Hospital as the Department of Justice looks to bring charges against Dr. Haim. Marcella and her team have been doing exceptional work to protect his First Amendment rights. And so tonight we wanted to just do some, give the attorneys an opportunity to talk about what they've been up to. And we hope that this is relevant for you in the medical profession to not only understand your First Amendment rights in the workforce, but also to know that there is help for you, that you are not alone, that we want to encourage you to stand up for your First Amendment rights in the workplace. So let's get started. I have a question here for Attorney Burke first. You have a very powerful testimony of how you stood up to religious discrimination in your own workplace and how you got to where you are today. Can you tell us that story and how it applies to what we are discussing tonight?
Sure. Thank you so much for having me. I'm Marcella Burke. I'm an attorney in Houston, Texas. I'm the managing partner and founder of the Burke Law Group. We started about 2 years ago, opened our doors. There were 7 of us. We all had jobs in top 20 and top 30 global ranked law firms, or were in senior executive service in the government. And as law firms become more hostile to these issues and other issues for our clients, we decided to start our own firm, not to take these issues specifically. Actually, we intended not to take big cultural issues. We just wanted to create a commercial law firm that would be a boutique to compete with some of these big firms, knowing a lot of our clients were sort of sick and tired of what was happening in the major global law firms. It's been about 2 years. We have 16 lawyers, and I think I'll be at about 30 lawyers this time next year. So we're growing. And we're full service. So we do corporate mergers and acquisitions, real estate, very boring, very standard. And then we have litigation, and we have all kinds of litigation. And so a lot of the major litigation we've taken on has ended up being in this arena. And it's mostly because we started getting calls from whistleblowers, and they would be referred to us from state attorney generals, from people in the media, or otherwise, and they knew we had this independent firm. They knew many of us were already nationally known attorneys in our own right, and they thought that we might be interested in taking some of these cases. And so a few of those cases we've taken are Dr. Eithan Haim in Texas Children's, a surgeon whistleblower. Vanessa Sivage is a nurse at Texas Children's Hospital as well. Jamie Reed in St. Louis, Missouri. We also represent a whistleblower at Vanderbilt, and we do a lot of amicus work. So when a lot of these cases pop up across the country, we will take cases representing different NGOs, nonprofit groups, or even helping states with their briefings. So we've represented Do No Harm in amicus work. We've represented the Ethics and Public Policy Center. We have represented the Independent Women's Forum at the Supreme Court in the recent Scrimetti case. Lady Golfers Association, do men have to participate in driving contests? So just all kinds of things. And my personal story, which I'll touch on, is that since the beginning of my legal career, there have just constantly been issues when it comes to conflicts with my faith, predominantly, and the type of work that happens at a law firm. And so as a first-year associate, you know, much like in the medical profession, credentials are very important, and credentials are, they will determine where you end up, where you practice. And so everything is a slog on the credentialing side. What law school you, what your LSAT score is, right? What your MCAT is, then what law school you go to, what clerkships or fellowships you get. I clerked for the Texas Supreme Court. I worked on the Fifth Circuit Court of Appeals for 2 federal district judges and for a Texas appellate judge. I had 2 fellowships in constitutional law and had really done everything I could to get the best credentialing and the best education, and ended up at a top global law firm. And once I got there, one of the first assignments they gave me as a junior associate was to do pro bono for Planned Parenthood. And that was just a group I wasn't wanting to work with. And it was for the clinic in Houston. That's the largest Planned Parenthood in the world, next to one in China. And I wasn't interested in taking that type of work. And so confronted very early on with a very hostile group of attorneys telling me I had to do this work, and having to learn how to navigate that. And so from a very early start, it was just a constant ducking and weaving, essentially, and taking very seriously that I can't bear false witness. So I wasn't willing to lie or manipulate, but also had to really be careful, really be savvy, and really try to continue to stick to my technical expertise. And so my technical expertise is actually environmental law, has nothing to do with any of these types of cases. And so that was often how I could sort of get out of a lot of that work and just do other types of pro bono work. As I advanced in my career, I ended up working in the government, held senior executive service positions at the US EPA and Department of Interior. I managed hundreds of lawyers nationwide for the federal government, came back and became a global energy partner at a top firm, and ran a global environmental practice. And so very prominent in the field that I'm an expert in. And also at the firm, they wanted me to get involved with mentoring and, you know, all these DEI initiatives. And I made it very clear that I was not interested in that. What I'm here to do is, you know, build my practice. And so began as a partner, starting to get a lot of conflicts with management. And ultimately, the management team of a firm I was with had changed composition, and they had wanted to start mandating things like pronouns on my bio or on my signature. And when I didn't argue with them, but I just didn't use it. And so they would have calls about, you know, doing work that would be supporting different abortion causes, for example. And I just wouldn't join the calls, but I'd have HR call me and say, we noticed you didn't join that call and there wasn't a conflict on your calendar. You know, why didn't you join? Or we've noticed that your signature, you know, everybody has a signature with pronouns now, and they made it so you couldn't manipulate it. And so I would just, it would auto-populate, and I would just delete the signature and copy and paste another signature, you know, from before the policy, and they HR noticed, you know. And so just living sort of in that regime. And in my practice, I was a top performing partner in the global law firm. And so it wasn't like I was a token attorney. I was really profitable and in my own right. And so I felt like I didn't have to capitulate to all these things. I was just there to do business. And eventually that just wasn't going to be good enough. And they had told me that it was a huge problem, in fact, that I wouldn't start cooperating with a lot of these programs, and gave me an ultimatum. And so for me, I just negotiated my way out of it. And I had, at this point, have become very familiar with a lot of the rights that we'll be talking about today, mostly around the Title VII, Title VI, whistleblowing, and all just sorts of general employee rights that you have. And so I ended up starting my own law firm in order to, again, just be a lawyer and to just be normal and take cases again. So sort of, I'll leave you where I started, which is now I have my own law firm. We have 16 lawyers. Everyone's highly credentialed, you know, Yale, Columbia, Stanford, Chicago, I mean, you name it. And everyone just wants to be a lawyer again. But these cases we've decided to take have really been career-defining cases, I think, for those of us at the firm. I'm very involved in them, and I can speak about them in detail because it's my role as the managing partner to support my partners who take these cases. But the lawyers who take them are the top of their field. Some of them practice at Department of Justice for over a decade, decades plus. in False Claims Act, in these types of discrimination cases. So we have true experts. And so that's a little bit of my background. I don't know if you have any specific questions on that, but if you guys have any questions, you know, at the end of this too, I'm happy to provide any more insight.
Fantastic. Thank you, Attorney Burke. I want to talk to the people that have joined us online that you can ask questions tonight through the Q&A link there at the bottom. And if you want to remain anonymous, you do have the opportunity to click the anonymous button if you when asking the question. So that's completely up to you. But yeah, so much going on in the legal world, as you mentioned, Attorney Burke, around you know, you just want to be an attorney, you don't want to get into the DEI stuff, and you know, we at Massachusetts Family Institute deal with this all the time. I want to switch over to Attorney Whiting. What conscience protections do state and federal laws give medical professionals?
Yeah, so I want to talk about a couple specific statutes that give protections to medical professionals in Massachusetts to not have to violate their conscience when they're performing, you know, specific procedures or refusing to perform specific procedures. So, you know, like Attorney Burke said, maybe you just want to be a doctor, maybe you don't want to be, or a nurse, or a you know, a psychologist. Maybe you don't want to be involved in whatever the cause of the day is, and maybe that violates your religious conscience. So one statute that I want to start with on the books here in Massachusetts that's state specific is Mass General Laws, Chapter 112, Section 12I. So don't worry about memorizing that. I'll put it in the chat for people. But this is a statute that actually gives Massachusetts physicians or any other healthcare provider, so it's very broad, who are employed by a hospital or other health facility. So again, very broad. The right to basically opt out of engaging in abortions or sterilizations. So what the statute says is you're not required to participate in those procedures. You're not liable to damages if you refuse to participate and someone tries to sue you and say, you know, I needed an abortion and you didn't provide it to me. You're not liable to damages, and you also can't be disciplined. So that means you can't be demoted, you can't be passed over for a promotion. So this is a very strong, clear law on the books in Massachusetts. As you might guess, it's kind of a relic of another age, but it's still on the books. It's still very much in force, and hospitals and other healthcare facilities do pay attention to this. We actually used this law last year as we protected the rights of a pro-life Christian pharmacist who did not want to be forced to dispense abortifacient drugs at her pharmacy when that national pharmacy started implementing a policy where they were going to give out the abortion pill. So we drafted a letter under Title VII, but also under this statute. And that was granted no questions asked. And I think in large part because of these statutes that are on the books, they know that they just have to comply with that. I also want to point out that this applies to students in medicine, nursing, social work, psychology. It's not just people who are actually practicing. So you can't be, you know, denied an education on the basis that you won't participate in abortion or sterilization. Abortion, I mean, abortion is kind of the procedure that I think most people know that there's something on the books for conscience protections, but I think it's interesting that this law also covers sterilization. And when this was passed some decades ago, I don't think they had in mind what's happening nowadays, where you know, doctors are literally, you know, being coerced to engage in sterilization procedures, sometimes even of minors, in the name of gender ideology. But sterilization is sterilization, and whether you're giving a child hormone therapy that's going to end up sterilizing them for life, or you're performing you know, a so-called gender affirming hysterectomy or something along those lines, I think you have a very good argument that that counts as sterilization under this statute. To my knowledge, it hasn't been that hasn't been litigated, but I think you'd be in good standing to say I have a religious conscience right not to engage in sterilization. So that's the Massachusetts law. Then the next one I want to touch on quickly is under federal law. There's a provision called the Church Amendments This is 42 U.S. Code, section 300A7. Again, don't worry about memorizing that. I'll drop it in the chat. But this basically forbids discrimination by hospitals or other entities that receive certain federal funds and grants, things like that, against a physician or other healthcare personnel who refuses on religious or moral grounds to participate in abortion or sterilization. So again, I do want to point out both these statutes, state and federal, allow opt-out for religious or moral grounds. You don't need to necessarily be religious to utilize these if these things violate your conscience. So the church amendments also broadly forbid entities that conduct federally funded health programs or research activities from compelling healthcare providers to violate their moral or religious beliefs. So even outside of abortion or sterilization, if you're talking about assisted suicide or another controversial healthcare procedure, if these healthcare programs are federally funded, then you do have the right to opt out. Now that all sounds great. It's a little bit narrower actually than the Massachusetts law though, because it only applies to programs that receive certain federal funds and grants. It's not every healthcare facility. And the other thing that is a little bit unfortunate about the federal conscience protections is that there's no private right of action, meaning that you can't just go and sue if your hospital tries to force you to do this. Most courts have interpreted it to not allow you to do that. So this would be enforced by the Office of Civil Rights. And in today's day and age, unfortunately, that means that it kind of depends on the administration whether your religious conscience rights are going to be protected. So under the Trump administration, there were some pretty significant enforcement actions under the church amendments. Under the Biden administration, OCR has been much quieter. So, I mean, we can, who knows what'll happen with the next election. This might have some life breathed into it if we get a Republican administration. But as of right now, I wouldn't necessarily rely on this. I do think the Massachusetts law is probably stronger. So I know Marcella is also going to talk about state and federal laws that prohibit religious discrimination and require employers to accommodate religious beliefs of their employees. And those are other laws that I think protect the religious conscience rights of healthcare employees. So I'll wrap that up, and I will again put those laws in the chat.
Yeah, thanks, Attorney Whiting. He mentioned several laws there, and maybe Attorney Burke, you want to just speak to, I mean, we talked about Massachusetts law, federal law, how are these applied to some of the cases? Maybe personalize this a little bit for us, in terms of the whistleblowers that you are representing. How are you navigating this? For example, Dr. Haim, what is the DOJ coming after him for? Where is that case? If you could kind of personalize this for us, that'd be helpful.
Sure. I'll generalize the comments because I just want to be careful to keep privilege, but there are certain things that are filed publicly that I can talk about as relating to specific clients of mine. But in general, when these types of things pop up, you have a couple different options. And so what I'll talk about briefly is Title VII of the Civil Rights Act. So Title VII is the law that we sort of all know about, where you cannot discriminate against someone for their race, their sex, their religion, and under a new Supreme Court test by Neil Gorsuch, Bostock opinion, sexual orientation, which actually we use to our advantage in some of our litigation. And so what that means is you can't be discriminated against in hiring while you're at your hospital, or if there's layoffs, if you can't be selected for a layoff based on any of those factors. And what's good for the goose is good for the gander in Title VII. Anything that you could imagine somebody would do against a Black person, discriminate in hiring, have a special recruiting event, give special scholarships, give special tuition waivers at medical schools, at your hospitals, have special events that exclude Black people, anything like that. You also cannot do against white people. You can't do, everything has to be totally equally applicable. The way the laws are written is based on a meritocracy. And so a lot of people are surprised to hear that because it's just so ubiquitous that every major corporation has these DE&I protocols, but they're totally illegal. So I'll just frame it by talking through sort of what we call a DEI scorecard. And the first stage in a life cycle of discrimination at companies is recruitment. So the talent acquisition stage at a hospital or at a clinic. If you see your company engage in any kind of targeted recruiting, diversity sourcing, meaning a company or recruiter seeks or screens candidates based on race, sex, religion, sexual orientation, totally illegal. Have you seen a company require a certain number of percentage of candidates? Percentages, quotas, totally illegal. Now, there's a small exception to this, which is if you work for a hospital and let's say it turns out that 30% of all brain surgeons are female, and at your hospital it's only 5%. Well, you can have initiatives that, as long as all things are equal and all the candidates are equally yoked in merit, choosing between two equally merited candidates, you can prefer a woman up to get up to that 30%. It's actually very rare for that to actually happen. It's a small exception, but in general, quotas totally illegal. Your company, your hospital cannot, if you've seen in a DEI training, a pie chart that has how many blacks, white, whatever people, Catholics, Jews, gay, whatever, they cannot share information like that. And there's lots of case law indicating it's illegal to even collect that information. And so certainly not to share it. If your company has diversity internships, scholarships, any kind of accelerated interview processes, totally illegal. Then there's, in the life cycle, for current employees, there's different DEI initiatives that we've had clients encounter. Did your company require employees to attend DEI trainings? Well, if so, what do they discuss? Do they discuss topics like unconscious bias training, cultural competency training, talking about DEI concepts like critical race theory, or any criticism of certain racial groups, like discussing white privilege? Totally illegal. Has the company ever separated employees into race-based groups for training or events? Having a training for transgender people specifically? Can't do that. You have to invite everybody to all the trainings. Have you separated trainings into racial groups or anything like that at all? Have there been restricted access to training, leadership development, or mentorship programs based on same-sex attraction, marital status, sex, race, any of that stuff? Totally illegal. If the workplace has affinity groups organized around race or sex or sexual orientation, they're often called employee resource groups or business resource groups. These are typically organized around a particular component of identity for typically diverse employees like LGBT employees. They can be restricted under certain categories. So there's allies, for example. All those types of things are very problematic. And then finally, there's DEI involved. Well, I guess there's two more categories. In management is another category, and corporate accountability and reporting. And so if the company has goals for percentages, again, totally illegal. Has company tracked the percentages of applicants, new hires, current employees, management, and promotions based on race and sex? This is really important, especially for people in management. When your bonuses are tied to recruiting or any kind of DEI matrix, they absolutely cannot tie any salary to DEI metrics. So if they include diversity activities in annual performance reviews, that's a problem. Do they tie compensation to any diversity representation goals? Totally illegal. And then there's another category, which is DEI policies at the end of the employment cycle. If the company's considered race, sex, or sexual orientation when determining whether to fire someone or to do layoffs, do they consider any of those things during a restructuring, a reduction in force, or voluntary or involuntary separation programs? And so if you see anything like any of the things I've listed above, that is all very problematic behavior. And there will be a number of questions that we would ask you. We have this, questionnaire. It's essentially a scorecard that we would learn about. I have clients right now who they had to take a DEI training, and in their training, they had a section on transgender, And it was sort of like multiple choice questions based on factual scenarios. And it specifically said in the prompt, and this is a generic prompt from a DEI sort of consultant, well-known company, that, you know, you may have been raised to believe that there were two sexes, but now we all know that gender is fluid. And at this company, we affirm whatever sex the person that they proclaim. And so it is our company policy that you will affirm the pronouns, name, and you will not discriminate. It's considered discrimination and you will be disciplined. And so they give a scenario and they want you to call them this pronoun. What are your options? And the 4 multiple choice options, all of them would violate the conscience of any Christian, Jew, Muslim person that isn't religious, but just believes there's two sexes. And so that was an issue that came up, and we had 2 people from that company. And it's a huge global chemical company, actually. And so representing them. And of course, in the transgender whistleblower case, we're going to talk about the False Claims Act sort of next or later. But if you see any of this stuff in the HR side of the house, these are all very problematic, and you can bring them up. And what we do usually is we put together a demand letter of sorts, and we explain to the company what's going on and why it's illegal. And you are protected once you make a claim or a statement. It doesn't have to be a lawsuit claim, so I don't use that legally operatively. But if you make a statement to the company, they cannot fire you. It's called retaliation. They can't demote you. I mean, you have job security when you bring this stuff up. And so you start negotiating. And we've had plenty of cases where companies will completely turn around their policies. It just takes one person to speak up and to get this stuff reversed. And because it's illegal and because they're so vulnerable, really they just rely on industries to stay quiet. And one thing I've learned in my whistleblower cases with hospitals is there is a really amazing just oppression of silence for anyone who disagrees with the especially the transgender agenda right now. And so it really does not take much to end a lot of this stuff, except for the fact that there's constant DEI training, constant affirming care training, constant gay flags and all that stuff all over the place. And so you feel like it's your job. But the fact is it's not the case. It is against the law. And there's lots of case law to back you up. And there's even case law in certain circuits that shows that basically it can be a hostile work environment. That imagine if you're a Black person and everything is just white this, white that, white this, white that, white promotions, white. Black people are lesser than, Black privilege, Black this, Black that. You could see that could be a hostile work environment against Black people. Well, certain circuits are now taking up cases saying that there's hostile work environment against Christians or Jews or Muslims or any people that just disagree with this ideology. And so that's really great. And the reason why these cases settle is because the left, not to be too gauche, but that's what it is, the ACLU and all these groups, they do not want these cases going up to the Supreme Court. The last time one did, they lost. And that was the big Harvard admissions case where the Asian students sued and won. And in that case, they said you cannot discriminate based on race. And they applied it throughout all Title VII. And they said it also applies to corporations. And so nobody wants to be the test case that really puts that DEI nail in the coffin. So what you're seeing constantly in the news, there's a guy named Robbie Starbuck. There's just a lot of sort of people that track this. And so you'll see companies like Caterpillar, Harley Davidson, John Deere, just completely do reversals of their DEI and ending all the transgender everything because they had someone speak up and it was a term of settlement to make it go away. So those are really interesting cases. We have had people who've blown the whistle on the transgender stuff, and some of them have had no employment problems, and some of them have had very serious employment problems. So when the problem comes up, you write that letter, your lawyers handle it. We make sure we preserve all your claims. And then what happens if the hospital says, too bad, you're fired, we don't care if we're retaliating against you, you file a claim to the EEOC. It's like a one-page form. It's a technicality. You wait 180 days. They're going to say they don't want your case. That's fine. And then you have a private right of action to then file a lawsuit under Title VII. Those are the cases that settle. And so most lawyers take those cases contingency, and you share the award between the attorney and the plaintiff, and there's opportunities for class actions. And so if you are with at the same place of employment, and there's multiple people having the same type of discrimination, then you can form a class. And that's more powerful because in that point, what they do is it's sort of a legal fiction. They will imagine that the three of you represent every single similarly situated person at that company. And then they will settle, they'll take your claim and they'll multiply it by how many people there are that fit that description. And then you as the class officers receive all of the windfall. And so that's what the class actions are, what they look like. It's basically the same process, but it's through a group of you. And so we have class actions right now representing groups of similarly situated employees that are challenging transgender programs at different companies across the country. And so it's really great. We haven't lost one of these cases. We call it our free money docket. I was very suspicious of taking employment cases when I started my firm, and it ended up being so successful. And the lawyer, and it's the kind of thing where there's just not a lot of law firms that'll take it, and a lot of employment lawyers don't want to take cases defending the Christians or whomever that want to stand up for the conscience rights. And so there's a lack of representation in the market, and so lawyers at our firm have stepped up. And so yeah, those are great cases. And so I guess I'll pause there on the Title VII piece. And we can switch or however you want to handle it.
No,
I don't
that's
want to
good.
keep going on. But
No, it's super helpful. We have some questions that maybe we'll get into right now, and then we'll go back into our prepared questions. But some of this is on conscience protections. So is there a way to easily find out conscience protections for healthcare professionals in other states, especially for non-physicians, as my state, Maryland, I believe has protections for physicians, but not always other healthcare professionals. Perhaps Attorney Burke, if you want to take that first.
so that's the exact type of question where we have to just look up state by state. I'm not aware of a resource. There might be one, and Attorney Whiting might be aware of one that would be able to tell you. You sort of go on a single website and they tell you what are all your conscience protections. That's the kind of thing, though, that's pretty easy for any lawyer to look up to see what they are, what state laws apply, and what federal laws apply.
So I will say too, there is the Maryland Family Institute, which just started. It does a lot of the same work we do here in Massachusetts. They would be a great contact. So if you just search Maryland Family Institute, I think the gentleman that leads that is Jeff Trimbath. Take a look at them for Maryland, and I'm sure Attorney Burke, you work in many different states, so I imagine that might, if there's something there, I'm sure you wouldn't mind working in Maryland. Second question, or Attorney Whitey, did you want to comment on that question at all?
Yeah, I think you guys covered it. That's what I was going to say, Mike, is, check out the local family policy council there. They often have legal connections. Obviously, Attorney Burke would be, and those types of private law firms that do that type of work would be a great connection. The only other thing that I would mention is groups like the Alliance Defending Freedom or First Liberty Institute. If, you feel that your religious freedom rights are being violated, they're always a great go-to as well.
Absolutely. Second question, in order to renew my license with the state board, I was required to take an implicit bias class. I'm sure you get this all the time, Attorney Burke. Is that illegal?
Probably. Yeah. I have to read what the questions were, but yes.
Yeah.
They typically are, especially the government cannot. So this is where, so all these things we're talking about are against private employers, Title VII. When it's the government imposing it, I would say it's even easier, because that's when you then have First Amendment. The government cannot infringe on your speech, and they cannot compel political speech, and they cannot compel religious speech. And so those are really fun demand letters to write, actually, because they don't take much time and a lot of research. We get to say fun things. Like one of our defendants they operate internationally and a lot in the Saudi Arabia. And we just made a comment that we look forward to seeing the discovery. They claim that everyone in the entire company globally has to take this training. And we made a comment. We're very curious to learn a discovery whether all of your Saudi Arabian employees and all your employees in the Middle East have to take the same transgender training. And so that got cleaned up pretty quick. But yeah, the government cannot give you a test.
Yeah. Attorney Whiting, we deal with this with the MIAA DEI pledge. We see some outlier schools that want to continue this kind of process, even saw that recently today. Attorney Whiting, do you want to speak to this as well?
Yeah, I mean, I think Attorney Burke covered it well, but I would say specifically with the MIA pledge, like Marcella said, if it's the government requiring you to especially state something that you don't necessarily believe, that's just a slam dunk case under the First Amendment, because there's such a thing as compelled speech, that clearly violates your free speech rights. Now, talking about taking an implicit bias course or class, yeah, I would defer to Marcella on that, but certainly maybe we should compare notes, because I think some schools are still requiring athletes, even if they're not requiring them to take this pledge, they're requiring them to do this implicit bias course. So that's getting a little far afield of healthcare conscience rights, I guess. But if you're in a workplace that requires you to take those types of tests or classes, certainly something that would be worth reaching out to somebody like Attorney Burke about.
Absolutely. And let's continue on this Title VII subject. Does Title VII apply to government agencies, municipalities, school systems as well? Does it apply only in the medical realm or any employment? Attorney Burke.
Any employer that has over 50 employees, private, government, anybody.
Okay.
Schools,
Yeah.
public schools, private schools, everybody. Now, there's a lot of, it's interesting, depending on whether it's a religious institution, there'll be different protections for religious institutions. And typically religious institutions are more, let's use the word conservative, but sometimes not. And so, but typically, if you're sort of a conservative Orthodox religious institution, so for example, I've represented Catholic universities, and there's a document called Ex Cordia Ecclesia out of the Vatican that says, here's how it's like a constitution on if you're going to be a Catholic university. This is what it's going to look like, and you're going to hire Catholics. I mean, you're going to discriminate against non-Catholics, and here's your quota, and this and that. It's like, and that is protected by seven separate statutes and 2 different provisions in the Constitution. And so, so depending on sort of, is it a Catholic hospital or not? You have a lot of leverage. Now, we work a lot with Line Spending Freedom and First Liberty as a law firm, and that's usually pro bono stuff. And a lot of times, my firm doesn't have the capacity to do a lot of pro bono because we're so small. So we'll work with ADF and we'll help them. And but ADF has a policy they can't sue religious organizations. So if it's a Catholic hospital, they can't do anything about it. But they've referred cases to us. So we have a case right now against a Catholic hospital in New Mexico that turns out provides over 78% of all transgender surgeries on minors and adults. And so they hold themselves out to be a Catholic hospital. They've got a crucifix on their homepage. They talk about Jesus all over the place. And when you go inside the hospital, our whistleblower there, there's all these documents on the LGBT stuff that's all about sort of like this non-Catholic version of theology that sort of backs us up. Anyway, it's a huge problem. We've got our Title VII litigation that we're working on, but we're also working with canon lawyers and the United States Conference of Catholic Bishops, and working with the bishops to have them lose their status as a Catholic hospital. And so there's also canon law. That's an avenue when you're working with a Catholic organization. And so if you're at a Catholic university or hospital, and these things are happening, there's actually tools you have depending on the denomination. There are certain Protestant denominations that are very strong on the life issues. And so, you can kind of dig into the weeds on whether it's actually, it actually is supposed to be a religious hospital or school. And then you have different sort of statutory levers that you can use in your favor and to sort of unwind those policies.
So you're making me think about something here in Massachusetts, Attorney Burke. So would this also apply? You mentioned Catholic. I don't mean to point out Catholics here, but we're talking about this subject. What about Catholic schools that are adopting DEI policies? Would you work with bishops, for example, in Massachusetts with canon law?
I mean, if there are bishops in Massachusetts that would like to defend traditional Catholic teaching, yes, we could work with them. They have their own canon lawyers too. You can also work, there's different things you can do in that situation. It's a little tougher. I'm a Catholic. I pulled my kids out of Catholic school for teaching sort of gay homosexual agenda as early as pre-K 3. And so at some point, there's only so much you can do. But yeah, I reached out to my bishop, you know, and you kind of work the system, but at the same, and I'm sure it'll, you know, over time it'll get sorted out, but I wasn't keeping my 3-year-old in that school, you know? And so, you know, it's, there are some of this stuff in practicality. Yes, you might have the law on your side. Yes, you might have your church teaching on your side, depending on your denomination. But then there's just the practicality of like my kid's in this school or I work at this hospital. Like, what can I do today?
Yeah. Specific question here. What to do in this case? A teacher at public school refused to use preferred pronouns of students based on her religion and was fired as a result. Applied to EEOC so she could get right to sue letter. EEOC wouldn't accept her application and so far cannot get the letter. Both of you should probably respond to this, but Attorney Burke, why don't you go first?
Yeah, they're just political jockeying. They don't want to give the letter. So this is when I said you go to the EEOC, you file your complaint. It's like a form, and then they have 180 days to quote investigate. And if you are on this side of the issue, they just sit on it, and then you ask for your right to sue letter. And we've had plenty of these where they just won't give you the right to sue letter, and it's just because there's some political hack in the agency that's refusing to give you what you're due, and they're probably waiting to see what happens in the election. This is the kind of thing where if there's a Trump administration, you'll be getting that right to sue letter pretty much immediately. Now, you still have a right to sue. And so you can actually file an administrative action against the agency compelling this letter for a right to sue. But again, that's more lawfare. And so really it's just a tactic to try to sort of slow down the inevitable. Also on cases like that, I mean, it is so clearly illegal and unconstitutional. The government absolutely cannot compel speech like that. And this is a perfect example of the case they don't want to bring. They do not want that case. They will lose the case. They will lose in the circuit court. They'll lose at the Supreme Court. And so you might get an activist federal district judge. You're going to have a harder time on appeal, and it'll be impossible in the U.S. Supreme Court. So, so there's also just sort of what those dynamics are.
Yeah, Attorney Burke, do you want to speak to that too, and perhaps even what a family policy council like MFI can do in that case?
I mean, what do you mean?
Sorry, I meant Attorney Whiting. I think I said.
Oh yeah, sorry.
Sorry.
I was like,
yeah,
well,
I was
if you
just-
can brief, I don't know.
Yeah. I echo everything that Marcel said. I would also just say that everything should be filed with MCAD and the EEOC, because if EEOC gives you a hard time, you know, I haven't seen MCAD do that same thing with holding off on a right to sue letter. And I think actually under Massachusetts law, I don't think you even need to get a right to sue letter. I think you just automatically have the right to sue after 90 days. So MCAD is the Massachusetts state equivalent. It's the Massachusetts Commission Against Discrimination. So file in both. In this case, you know, as long as you're not past the 300-day deadline, I would file with MCAD as well. But certainly would be happy to talk with this person further about that.
Yeah,
That's a really good point. We haven't mentioned yet. Sorry. There's Title VII, it's a federal law, but there's also state laws, and almost every state has a Title VII equivalent. Texas has, you know, their own everyone. And so the federal law is the floor. But some states there, you know, can give you more rights, and it's like a ceiling. And often what they've done in states like California, New York, Washington State, they've given, quote, rights to all these different groups, but it turns out those rights apply to everybody equally. So some of those states are the best ones to sue in, actually. And if the federal government won't get back to you and you filed in the state's going to give you more rights, like we're saying in Massachusetts. Well, it turns out you automatically get a right to sue. And so sue in state court.
Who would have thought that Massachusetts would be a good place to sue on that kind of stuff?
Yeah.
You'd have more rights in Massachusetts. That's great. Let's go to this next question, Attorney Burke. You have also taken on some major cases under the False Claims Act. Can you tell us what protections this law gives to medical professionals who may be asked to go along with the dishonest billing practices by their employers?
Sure. So the False Claims Act is another statute to be aware of. So in Title VII cases, a couple things. You have 300 days is your statute of limitation. So if you wait too long, you're not going to be able to sue. And also your damages could be for your back pay, or there can be punitive damages. Really, you're sort of limited to what salary you lost or would have lost, and some other punitives. I mean, there are cases under Title VII where, for example, at Starbucks, they fired a woman for being white in a district where they just wanted a black manager, and she got a $25 million judgment, and it got upheld. Okay, so you can make a lot of money. Again, she was in the right state. She was in a blue state. And so it depends on sort of tort reform and what state you're in. But typically, you're not going to get $25 million. For the False Claims Act, it's a little different. So False Claims Act is a statute that basically says you can't steal from the government. And so Medicaid and Medicare, TRICARE, or any state like CHIPS or whatever program for healthcare, if you're working at a clinic or a hospital where it is either you're in a red state and it's illegal in your state to do these at all, or you're in a blue state, but Medicaid doesn't cover the treatments. They don't cover transgender for minors. And so if you know that it's happening, and what they're doing is they're doing false billing codes. So we've had a number of people call us and tell us about how they work in a clinic, they work in a hospital where other people are talking about it, or they've had patients come in and they see the chart and they're just sort of horrified at what they're seeing. 11, 12, 13-year-old girls coming in, and maybe they're getting testosterone and the chart, says it's Steve. And the chart doesn't mention that Steve is actually Susie. And so Steve is estrogen deficient. It's like, well, no, but, no, Steve's not. Steve is Susie or whatever. They're giving a boy estrogen. They're giving a girl testosterone. They're saying that they have precocious puberty. And so they need to give, puberty blockers. They're saying a 13-year-old girl needs a breast reduction. And the chart shows she doesn't even have breast buds. And then the chart reveals there's a double mastectomy and a shoulder reconstruction. And, she loves the way she looks and she's getting her testosterone. And so really, they'll just use these billing codes. Often they'll say it's endocrine, non-specified. And so they get the billing code to get the treatment, to do the intervention. And then Medicaid or TRICARE will pay for it. And then they just sort of ignore it on the back end. And there's really no way to know, especially when the charts don't really indicate the sex. And if the state attorney general or someone wants to do an investigation, it's hard to pull the files and know what to look for. You really have to look for precocious puberty at like blood tests and things. And you really have to get a lot of experts. And so what we've started doing is working with whistleblowers who know all about this. They know all the receipts. They know exactly who the patients are, what their ages are, what their true sex is, what treatments they're getting, what billing codes are being used. And so we'll work with them and we'll train them. We'll train them in how to collect this information. We'll train them in how to preserve it. We'll train them in how to remain completely anonymous. And under the False Claims Act, the way that damages model works is you become a witness, is essentially what you are. You're not a plaintiff. You're not a defendant. You're not defending yourself. And you're not representing the hospital. You are just a witness. And you're telling essentially the government, so it's filed jointly in state and federal court in a complaint, that you have information that there is fraud going on, that they're stealing under these billing codes. And so it'll get investigated by the state. And after they complete their investigation, and typically when we do these, we collect all the receipts, including payment on the back end. which we have separate whistleblowers who help us on the insurance side. So we don't have to do 2 years of discovery to figure out, did Medicaid actually pay the hospital back? We already have all those receipts. So when we file our complaint, it's all there. There's no denying it. We've taught our whistleblowers exactly how to do it. No one at the hospital even knows who they are at this point because it's completely secret, the False Claims Act. There's also separate employment provisions protecting you under the False Claims Act, against retaliation, which are very strong. And so, when you're doing the False Claims Act, the hospital is going to be investigated by the state and the federal government combined. And so, even in a Biden DOJ, we work with prosecutors where those employees are very, very well protected. I can talk about Dr. Haim. His case is a complete anomaly, generally on how these cases are handled. And so what happens is, if the government then finds there's been fraud and abuse, then they will collect that money from the hospital. And so the average child, it might be $1 million in medical services. You know, we have 25 doctors seeing a patient in a year, and then seeing their sister and their brother and their mom and their dad, and everything from psychiatry to psychology to all the endocrine. I mean, y'all know, heart, lung, bone, everything. And so about $1 million a patient, but under the False Claims Act, they have to pay treble damages, which means triple damages. So for the $1 million they owe per child, it'll be $3 million. And they'll look through the system and they'll find not just the people that, you know, the witness identified, but they go through the system and they find everybody for the past, say, 10 years. And we're talking $1 billion being stolen from the government over the past 10 years in dozens of hospitals across the country. It's totally ubiquitous. We have a whistleblower who ran a clinic, and her clinic in the Midwest ran a training that was multi-state. And there were slides in the training saying, here's the codes that, you know, it should be billed under, like F64 codes or whatever. But Medicaid doesn't pay for it, and it's not fair that poor people shouldn't be able to get the same treatments. So here's the codes you should bill anyway to get around Medicaid. That is incredibly illegal. She recorded it. And so that's actually federal RICO, racketeering. I mean, that is like interstate fraud being promoted. These are major cases. And so the whistleblower has lots of protection. And also, at the end of the day, when the lawsuit is settled, you know, you're only involved. They might interview you to be a witness, and then you don't really hear back until later the hospital settles. It could be for $500 million, and you're entitled to 20, it could be 20% of every single dollar the government collects, just because you're the one who had the courage to say something. Some of our whistleblowers still work at the institutions where they're the key witness, or they're the first witness. The government ends up collecting lots of witnesses, and they just become one of many witnesses, and you're just a witness. And no one knows which witness you were. And so that's sort of the beauty of it. And so then you just wait, and then there's a massive payday at the end of the day. So those are really, really interesting cases that we've been taking. And those are ones we're just super curious about. And I'll say this too, False Claims Act, you know, Title VII also has something in, it's Title VI actually. If you're a hospital or a clinic and you get government contracting, which means you use Medicaid, for example, and there's a Title VII problem at your hospital. Well, under so there's an employment, right? Like a discrimination problem at your hospital. Well, Title VI says that if you are having government contracts, you can't violate Title VII. And so you could be a whistleblower under Title VI at a hospital that uses Medicaid because of a Title VII problem. So there's lots of different ways. Essentially, all this stuff is totally illegal. And there's ways that you as a whistleblower could collect damages, but also really be a key person to put whatever these DEI programs, or if they're straight up stealing and lying and fraud, to put an end to it. And frankly, a lot of these hospitals, they're not going to stop until they have to pay. And so for a number of the hospitals, they had a whistleblower. The attorney general did an investigation. There's a bunch of press releases saying, we don't do it, we stopped doing it. They take it off the website, they apologize. And then what happens? Another whistleblower calls us and says, I'm at the same hospital, they're still doing it. They're still doing it. And so you just have to keep on them. And so if you're at a hospital, but there's already been an investigation, it's not over. If they're still doing it, it's illegal, and there'll be a second lawsuit. So for some of our whistleblowers, these hospitals are facing now their second round against the government, and the government is not happy.
So many opportunities to be a whistleblower. I think, people listening tonight should really be encouraged, right? That you have a lot of rights, and a lot of times it's just fear that's keeping you back. So it's really encouraging. The last question tonight for both of you: what other issues does Massachusetts Liberty Legal Center and the Burke Law Group encounter when it comes to healthcare conscience rights, and how have you been able to help medical professionals? Perhaps Attorney Whiting, you want to start with that, and then we'll go to Attorney Burke.
Yeah, so and this is kind of a broad, open-ended question, but I wanted to just maybe put on everybody's mind quickly here because I know we want to wrap up fairly soon. A few of the major issues that we encounter. So we've already discussed employers forcing the use of transgender pronouns for patients, for other coworkers, forcing pronouns into your bio, like Marcella was talking about. So in most situations, this comes down to a religious accommodation issue. And in that kind of situation, you're going to be able to file an accommodation request with your employer saying this violates my religious beliefs. This is how you can accommodate me. Can I use last names for patients rather than using pronouns, or something along those lines? We can help you with that. I will say if you can avoid the issue entirely, it's always best to do that. Just try to slide under the radar. But if not, then we can certainly help you draft an accommodation request. So pronouns is a big issue. Another one is government attacks on free speech. So I saw that we already have a question here about the Pregnancy Resource Center smear campaign. And here in Massachusetts, the state has been trying every single tactic that they can think of now, including upwards of $1 million smear campaign to defame pregnancy resource centers. And so what do you do in that situation? The only thing that you can do is sue for a violation of First Amendment rights. So that's what we're doing right now with the ACLJ, the American Center for Law and Justice, suing Maura Healey in the state for that smear campaign. Another thing that comes up in Massachusetts along the lines of First Amendment issues is the counseling ban, what they call the minor conversion therapy ban, which says that you cannot engage in counseling that's intended to change the gender identity or sexual orientation of someone who's under 18. We think that this is very likely unconstitutional. Unfortunately, here in Massachusetts, we don't know what way the federal courts would rule on this. In the Ninth Circuit out in Washington recently, they actually upheld a similar ban out there. So at some point, this is probably going to be challenged here in Massachusetts, depending on whether there's the right plaintiff, whether they actually try to enforce this. I will say, to our knowledge, this law has never been enforced. I think there's some evidence that this might be more kind of virtue signaling than it is something that they're really coming after people with. But one thing that I just want to say about this conversion therapy ban, so-called conversion therapy ban, is that not taking an affirmative approach of saying that, yes, you actually are this opposite gender is not the same thing as conversion therapy. Under this law, the only thing that counts as conversion therapy is if you're actively trying to change a minor's gender identity. But it actually has an exception for practices that facilitate an individual's coping, social support, and identity exploration and development. So if you're just helping a kid work through gender confusion, but not necessarily pushing them either direction, but if their parents come to you and say, I'm worried about my child and what they're going through with this gender dysphoria, you're still able to do that under this law. So I did just want to comment on that. Then the last thing real quick is just upholding parental rights. We know that a lot of doctors' offices try to get their providers to separate parents from children in the doctor's office, for various odd reasons or nefarious reasons, trying to push birth control on minor girls, things like that. So as healthcare providers, you do not have to comply with this. Again, you have the right to ask for religious accommodation if they're trying to force you to do this, to separate kids from their parents and doctor's appointments. And unless a minor, affirmatively asks for the parent to get, not be involved in their healthcare, and they can legally consent to that healthcare, which they can in some circumstances in Massachusetts. If you're talking about things like, birth control, unless the minor actually asks you and tells you, "I don't want my parent involved," the parent has an absolute right to be there. So just want to encourage healthcare providers to try to uphold parental rights to the extent possible, because parents are very much under attack right now when it comes to their children's healthcare in a lot of circumstances.
Yeah, and Attorney Burke, before you comment on that last question, just to reiterate the question that Attorney Whiting was talking about, it says, how do we counter Massachusetts Medical Society trying to pass resolutions opposing deceptive practices by PRCs, Pregnancy Resource Centers, supporting transparency and full disclosure regarding scope of services? We've seen this a lot on a local level here in Massachusetts, where local ordinances from city councils against, quote unquote, false advertising practices of pregnancy resource centers. We've been able to successfully defeat those in Worcester, Framingham, and East Hampton, Massachusetts. And then you have this smear campaign. So this is definitely a big deal in Massachusetts. And I don't know if you've seen this in other places across the nation. This attack since the Roe v. Wade was overturned, this now renewed attack on PRCs has been front and center in Massachusetts.
I think as like a closing statement, I'll comment on sort of the catch-all question. What else do you see as attorneys and counsel on? I think that the takeaway I'd like to leave y'all with is really, when I take these cases, when our firm takes these cases, they're not profitable cases. I mean, the False Claims Act might be in a few years, please God, but it's just not. Right now, it actually costs me money to pay the lawyers to file them, and maybe in a few years it'll work out. Okay. So we're doing it because someone needs to do it. And I'm in the business, we say it's our free money docket. We kind of say that in jest with some of the easy ones, but really it's our freedom docket. And that sounds really cheesy, but it's just true. And my son, who I pulled out of that terrible school, and now he's at an amazing school, is learning that speech from Braveheart, or William Wallace, like, I am William Wallace. And I have to listen to it 10,000 times a day. And it's actually amazing because, this is when he's like, will you fight? And they say, well, fight against this? No, we'll run and we'll live. And he says, yeah, I fight and you may die, run and you'll live at least a while. And dying in your beds many years from now, would you be willing to trade all the days between this day and then for one chance, just one chance, to come back here and tell our enemies that they may take our lives, but they will never take our freedom? And I just love that I get to hear this 10 times a day, because at the end of the day, you still live in America. It's just a job. And what they're doing is truly destroying our country. It's destroying your state, and it's destroying children's lives and families' lives. And so, I mean, we have really big whistleblower cases. I had a state attorney general call me and tell me, I saw this case that y'all just took. I saw it in the news, and you call your client and you tell him to come to our state. And we will, if he loses his license in Texas, he can move here and we'll make him a doctor. Okay. You can move. I mean, there's a family in Washington where there's a woman who they're going to take her kids away because she doesn't want them to do this transitioning stuff in school. And I'm like, move. And she's like, but we have such a beautiful view. And I'm like, they're going to take your kids. You still have a lawsuit, even if you move jobs. You still have a lawsuit, even if you move states. And at the end of the day, it's really hard. I was at a law firm. I was finally making the 7 figures. I was finally living the life. And at the end of the day, it was pronouns. I'm not going to do it. I cannot bear false witness. And when I said no, I might have lost some money temporarily, but I gained freedom. I got to be free. And it was amazing. And I started my own law firm. So maybe there's a plan God has for you in your life to do something different. And so there's just this fear is sort of my point. Everyone's so afraid. What if I lose my job? What if this? What if that? It's like, yeah, you could. Some of my clients have. Most of them haven't. But for the ones who have, they've ended up on some amazing trajectory. and they're still right, and they're still going to eventually win. And so anyway, this is to say these are really treacherous times. These are really tough issues. If you're a Christian or a Jew, you can't bear false witness. You just can't. And so at some point, you're going to have to out yourself. And so what I would say is call a lawyer. Don't make any moves until you've talked to somebody. Get some high level advice on what you're going to do. And then you just take it one step at a time. You do one step at a time. You ask for the accommodation. What are they going to do? They say, well, we'll give you a partial accommodation. So then you want another accommodation. And you got a couple of months of that. Maybe you get fired. You probably won't. Maybe you will. False Claims Act. You see all this fraud. Oh my gosh. You will never sleep better until the day you call a lawyer, find out what your rights are, and decide that you're just going to live your conscience. So anyway, I think that's it. It's really fun taking these cases, and it's really cool working with people and reminding them of that first call, crying and panic and like terror. And then, you get into it. And that's the thing about virtue and about courage, is that once you exercise it, you actually build that muscle, you get stronger, and you don't feel like you're being brave anymore. Dr. Haim will argue with anyone who tells him he's brave. He's like, yeah, it might have been brave then, but now it's the most obvious thing to do. And so it's kind of like, what's it going to take to make Eithan do something that takes courage? He's got so much of it at this point, but he doesn't feel like he's being courageous anymore. He just feels like he's doing what he has to do. And so there is hope at the other end of these horrible scenarios that you're in. And another thing that I like to do is I introduce whistleblowers to one another. And so when people are thinking about blowing the whistle, there's a number of these guys and gals, nurses, doctors, clinic directors. Sometimes they're staff. They're not all doctors. And they talk to each other. And we have sort of a little support group and, compare notes. So it is a big, bold, bright, free world out there. Okay. And if you're working somewhere that's such a hostile work environment, you might as well get your check on the way out, because you should leave anyway, because it sounds like a miserable place to work.
I think Attorney Burke, Mel Gibson's going to be calling you for his next casting call for the next rendition of Braveheart. No, but that is a really encouraging final note that, we have more freedoms than we take advantage of, I think, too, right? I mean, it's fear that's keeping us from, the law is many times on our side. And I really like what you even said about, move, get out if that's what you have to do, and then you still have a case. So encouraging that someone would call you from another state and say, come be a doctor in my state. I mean, the United States of America is becoming very much like that, right? That, you're moving to states, not necessarily because, for reasons of freedom, right? Other than what was traditionally a reason to move to a state. Attorney Whiting, do you have any final thoughts as well on these subjects?
I think that sums it up really well. I don't have too much to add, and I want to let people, go to bed. But this has been a really good and encouraging conversation, and definitely thank you, Marcella, for joining us tonight.
Yeah, and I just received an email, Attorney Burke, about a lady from the audience that wants to contact you on the Title VII issue, the teacher that got fired for misgendering, which makes me think, we made this about the medical profession, but, we see, if not more, violations in the school, in the education field. So definitely, as you guys listen tonight, if you know people in the education field that, their First Amendment rights are under attack, please reach out to Massachusetts Family Institute and attorneys from the Burke Law Group, like Attorney Burke. So I want to thank you, Attorney Burke, for joining us tonight. It's very helpful. This will be recorded, so we will be able to send this out to people that have additional questions or want to see it. So again, thank you. And it was great meeting you at the ADF conference, and we hope to be in touch to protect more First Amendment rights of those around our great nation.
Thank you very much.
Thanks so much.
Night.